Good evening, everyone, and welcome to our discussion of Ghana legal system and legal method. So for the past 3 days, we have been discussing sources of law, and we decided to go bit by bit, taking each of the sources in a little bit more detail and looking at them in that order. So we initially discussed the Constitution as a source of law in Ghana. Then we subsequently discuss enactments or legislation or acts of parliament. And just yesterday, we discussed delegated legislation or subsidiary legislation as a source of law in Ghana. So just in case you miss it, the previous videos are available. And I did make the point that these discussions are based upon how I have treated the subject in the second edition of our book, Ghana Legal System and Legal Method. So tonight, we are discussing in a very brief session, the existing law as a source of Ghanaian law. And just before we proceed, it suffices to remind you that having regard to Ghana legal system, it is a very foundational subject. It's foundational subject in the sense that every law student must properly understand Ghana legal system if you are to do very well in the law, because Ghana legal system is supposed to be the very basis. And again, those who are preparing also for Ghana School of Law and Trade examination, as well as those who are lawyers from other jurisdictions, those who've qualified as lawyers from the UK, Nigeria, Gambia, Sierra Leone, Rwanda, name it, and you want to be called to the Ghana bar, so you have to go through the post-call course. It is pertinent that you also have a proper grasp or understanding of Ghana legal system and legal method. And for that matter, source of law is really important. So having said that, since we are discussing the existing law as a source of Ghanaian law, what is it? If we look at Article 11 plus 4 of the Constitution, it is broadly explained or broadly defined to encapsulate written and unwritten laws which were enforced prior to the 1992 Constitution coming into force. So all the laws, both written and unwritten, which were enforced in Ghana before the critical date, 7th January 1993, they are known as the existing law. So therefore, the existing law is a term of art, and it is equal to all written and unwritten laws in Ghana in force just before the midnight of 7th January 1993. And it's not 1992, please. 7th January 1993, just before that, all the laws that were enforced in Ghana, those are the ones the framers of the Constitution have used the phrase, the existing law. So let us keep that in mind. And for that matter, the existing law encompasses acts of first parliament, second parliamentary parliament, decrees of various military regimes, laws, that is PNDC laws, statutory instruments, the various allies that were in force before after the 1992 Constitution had come into force. So let's keep that in mind. So in terms of the relationship between the existing law and the 1992 Constitution, with respect to validity check, point needs to be made that existing law must align with the Constitution. That is to say that it must be in harmony, it must be in agreement with the letter and the spirit of the 1992 Constitution. And the implication is that, of course, as we have discussed from our very first lecture, the 1992 Constitution as a source of law, we know that any law, including the existing law, which is found to be in contravention of the Constitution, pro tanto, or to that extent, becomes invalid. And we know that the Constitution is supreme, and that is why existing laws must also conform with the Constitution. So if you wanted to illustrate, if we take the Evidence Act, we used to call the Evidence Decree, 1975, NRC Decree 323, for example, it remains valid despite the fact that it predated the 1992 Constitution, because it is found to be in harmony. It does not contradict, it does not contravene the letter and spirit of the 1992 Constitution. So let us keep that in mind. Of course, we have noted in Article 1, Clause 2, the doctrine of constitutional supremacy, which is basically that all laws that are inconsistent with the Constitution are automatically invalid, and a declaration will be made to that effect if the attention of the Supreme Court is, for example, drawn to it. And in that regard, so it is important to know that where you have, let's say, existing law, which is inconsistent with the Constitution, there's no need for another law to be passed by Parliament to repeal an existing law which is unconstitutional, because where existing law is unconstitutional, automatically it is invalid. So the Constitution has provided its own mechanism of validity. And if you look at the Article 11, Clause 4, it's quite explicit that where existing law, for example, is found to be inconsistent with the Constitution, then it's automatically unconstitutional, it is null and void. And there is no need for Parliament to pass any law to achieve that. And that point was also re-echoed by Justice Akwa, as he then was, because he subsequently became the Chief Justice. In the well-known case of Mensima against the Attorney General, if you remember, Mensima against the Attorney General, the case about the alcohol distilleries, if you remember. But the dictum he made, which I have quoted, is also in our chapter 3, is that, quote, in my view, therefore, Article 1, Clause 2 of the Constitution is a bulwark which not only fortifies the supremacy of the Constitution, but also makes it impossible for any law or provision inconsistent with the Constitution 1992 to be given effect to. And once the Constitution 1992 does not contain a schedule of laws repealed by virtue of Article 1, Clause 2, whenever the constitutionality of any law vis-a-vis a provision of the Constitution 1992 is challenged, the duty of this court is to examine the relevant law and the Constitution 1992 as a whole to determine the authenticity of the challenge. And in this regard, the fact that the alleged law had not specifically been repealed is totally immaterial and affords no validity to that law. For Article 1, Clause 2 of the Constitution 1992 contains an inbuilt repealing mechanism which automatically comes into play whenever it is found that a law is inconsistent with the Constitution 1992, unquote. Yeah, so that dictum by Akwa GSC in Mensima against Attorney General reinforces the point that we have made, that where an existing law is unconstitutional because it's not in agreement with the letter and spirit of the Constitution, there is no need for explicit legislation to be passed to repeal an existing law because it is unconstitutional. No, automatically it will cease to be part of the laws of Ghana, as it were. Yeah, so you could have conflict or conflicting existing law, as we have indicated, and where you have a conflict between aspect of existing law and the Constitution, what needs to be satisfied is what we call the conformity requirement. That is to say that it is the portion of the existing law which is found to be inconsistent, which will be modified so as to bring it in harmony with the letter and spirit of the Constitution. And what that means is that it is not necessary for the entire existing law, part of which has been found to be inconsistent, to have the whole of it declared unconstitutional. No. It is only the portion, only the part of the existing law which is unconstitutional, which will be declared as such. And then the rest of the existing law will be saved as still remaining part of the corpus or the body of laws of Ghana. So let's keep that in mind. So there are two things. Where you have conflicting existing law in the sense of a particular existing law, certain provisions of it are in contravention of the Constitution, it's those provisions that will be struck down as being unconstitutional, and then the rest would actually remain. Yeah, so let's keep that in mind. And this obviously ensures that existing law are updated to meet constitutional standards without unnecessary validation of the entire affected existing law. So let's keep that in mind. So then, what are the categories of existing laws? So in terms of Article 11, Clause 4, we've seen that all written and unwritten laws which predated the 1992 Constitution. And despite the fact that we're using 1992, it doesn't mean that laws which predated 1992, but laws which predated the coming into force of the 1992 Constitution. And as we have indicated, that is 7th January 1993. So they are called the existing law. So in terms of maybe organization or categorization, we could say that that would include laws of the Gold Coast. So there's something called the laws of the Gold Coast. There's a collection of, if you go to maybe BAM Library, you go to KNUST Library, University of Ghana School of Law Library, the courts, if you go to the libraries of the courts, Supreme Court Library and other courts libraries. And I think these are the libraries that I visited, maybe the other places so they may have. You will see some old bound volumes, and they are usually brownish. So they are actually called like the laws of the Gold Coast, collection of all the laws of the Gold Coast up to 1951. So up to since the the colonial administration started, up to 1951, the various laws which have been passed, they have been collected together in a volume. That is what we call the laws of the Gold Coast, 1951 revision or revised. And then we also have ordinances from 1952 up to 1957. The various ordinances which were passed by the various assemblies, they are also part of the existing law. And again, acts of parliament passed by the parliament we had in Ghana from 1957 to 1960, from 1960 to 1966, and then from 1969 to 1972, and then from 1981, sorry, from 19, yes, so yeah, because that was a short-lived, so 1979 to 81, the parliament, which worked briefly there, the acts of parliaments which were produced by these three parliaments are also called part of the existing laws of Ghana. And then again, the decrees are laws which were made by the various military regimes. You notice that our various constitutional democracies were disturbed by coup d'etat, and we've had a couple of them. Thank God, the 1992 constitution has survived more than 3 decades, and our militaries have been more sensible in terms of upholding the spirit of the will of the people and not interfering with democratic arrangement. So that is good. Just like what developed democracies like the US and the rest, what they have done. So we hope that we too continue to have our constitutional democracy remain in force until the Lord Jesus Christ returns. Good. So the various military regimes that we had, they had their laws, and we call that decrees. So we have like what we call the National Liberation Council, the first one, which overthrew Kwame Nkrumah. So they have their decrees there, and they were between 1966 and 69. And then we also have the Champon-led coup d'etat, National Redemption Council, which also came into the scene, what do you call the 72 to 79, which metamorphosed into Supreme Military Council 1, Supreme Military Council 2. So the decrees which were made by all these National Redemption Council, Supreme Military Council 1, Supreme Military Council 2, are all part of the existing law. And again, we also have what we call the decrees by the Armed Forces Revolutionary Council, which did the June 4th uprising led by the young man J.J. Rawlings at the time in 1979. And later on, when his stage is come back after disrupting the Third Republic and overthrowing President Limand, led Fourth Republic, he established what we called the Provisional National Defense Council, PNDC. And strangely, they decided to break with tradition, because the tradition or the convention was that all military regimes which made various laws, we simply call their laws decrees. But they decided to call their laws not decrees. They call their laws laws. And that is why we have PNDC law 111, maybe interstate succession law, PNDC law 152, 930 registration law, and so on and so forth. So from 1981 until 7th January 1993, we had a number of laws, and they were made under the auspices of the Rawlings-led Provisional National Defense Council military regime, and we call them PNDC laws. And they are part of the laws, the existing laws of Ghana we are talking about. Now, after the coming into force of the 1992 Constitution, there were certain developments. Parliament set up what we called the statute revision commissioner, and he sought to revise the laws of Ghana. And this involved consolidation and revision. So he revised and he consolidated and ensured that the various laws which were not in harmony with the Constitution were actually taken out, and so on and so forth. And again, it also sought to transform military government decrees into Acts of Parliament. And that is why you notice that if you take the evidence decree, for example, right? We used to call evidence decree. We no longer call it that, we call it Evidence Act. Despite the fact that it was passed by the military government, because in 1998, Parliament passed at 565, called the revised edition of the laws of Ghana, and it sought to automatically convert all laws which were made by military governments into acts of parliament, because we didn't want to have these shadows or the ghosts of military regime still lurking in the shadows, harassing us. So we wanted to say goodbye to them. and Parliament wanted to give its own legislative imprimatur or legislative blessing upon the decrees and all that which the military regimes made. And that is why they transformed them into acts of parliament. So that is the explanation. If you see that certain decrees are no longer called decrees, but they are called acts of parliament. And of course, existing law in terms of effectiveness, they have the same force of law as even new enactments passed by the Fourth Republican Parliament. So long as the existing law has passed the test of compatibility with the Constitution, in terms of efficacy, in terms of effectiveness, it has the same force of law as acts of parliament. So let's keep that in mind. Now, just before we finish, a general principle we need to advert our mind to. That is how you resolve conflicts between laws generally. There's a principle, if you go to chapter 3 of our book, we have stated this, the leges posterioris priaris contrarias abrogant. I mean, that legal principle simply means that later laws amend or repeal earlier conflicting laws of the same kind. Now, what does that mean in effect? That is to say that if Parliament, for example, has passed a certain law today, and the subject matter in respect of which Parliament has legislated, there were certain laws in respect of that same subject matter before. Now, even if Parliament does not make explicit reference to the existing law in the new law, if there is conflict between the new law and then the existing or the old law, then according to the principle of leges posterioris priaris contrarias abrogant, the new law which Parliament has made will be deemed to actually be to have repealed the existing law. So that is the principle of law which we have to take note of. Yeah. So once we know this, I think that we have studied existing law as a source of law in Ghana very well. If you have any question, you can put up your hand and then I'll take it before I end this short session. Any question, you can raise up your hand and then I will release your mic. Let me see if there's any hand up, otherwise I'll end the session. No hand is up. Okay, if there's any particular question you want me to help you to, you can also put it on the various platforms and I will look at them. All right, then have a good night.